Gene Mulkey.
Here.
Tom Hassler.
Here.
Bruce Forster.
Here.
Okay, thank you. And in our agenda, we have a little housekeeping things to change, so we're going to move on with new business. And first item is that we want to adopt the 4 transcripts we have as minutes for these first meetings we had. So if there was board members like to make a motion to approve making the first 4 transcripts be supplied as minutes, the floor is open to that.
So moved.
Moved by Bruce, is there a second? Second by Gene. Any more discussion? Questions? Hearing none, all in favor say aye.
Aye.
Both same sign. That motion carries. Then, the next thing we need to do is approve these transcripts, which are now minutes, as minutes of the first meetings. Is there a motion to approve those minutes? Is that Gene? Mike, okay, second.
Second.
By Bruce. All in favor say aye. All same sign. Motion carried. 2 things done. Third thing, we now are going to take our usual minutes of the zoning board along with the transcript that our court reporter is doing. And so we need a motion to have our clerk take her minutes as we previously had done starting tonight. Is there a motion on the floor for that? Yeah, Gene, is there a second?
Second.
By Bruce. Any more questions or anything on that? Seeing none, all in favor say aye.
So, Craig,
What's that?
so then the transcripts will be available or won't be available?
According to what Chris had mentioned tonight, they're going to be online things the next day if there's no mechanical problems.
Once they're received from our zoning to our zoning office, then I'll get them online.
Yeah,
Yes.
the transcripts. And our minutes will be the type that we normally have, which are more general, not word for word minutes, just topic minutes type things. So, yeah. Any other questions? Seeing none, all in favor of that motion, say aye.
Aye.
Opposed, same sign. Motion carries. That concludes our business that we need to take care of, so we will now move to the continuation of the hearing and turn it over to Judge Slater.
Thank you, Mr. Chairman. Welcome and good evening, everyone. I know this gets repetitive, but in case there are new folks here. My name is Tim Slavin. I'm a retired judge engaged as an independent contractor to what is called facilitate this hearing. I have no adjudicatory responsibilities. I am not for or against any particular position. I am a neutral. I am here hopefully to add some organization, efficiency, and flow to the proceedings. This is indeed Green River Wind Farm Phase 1 LLC's application for 46 special use permits as part of a wind energy conversion system. As shown by certificates of publication, notice of this hearing was published in the Dixon Telegraph on June 18, 2012. Notices to adjoining property owners have been provided. All who so desire will absolutely be given an opportunity to be heard throughout these proceedings, but for everyone's benefit, I want to do it as orderly and as efficiently as possible. There are many possible reasons for anyone's appearance here this evening. You could be a member of the public as a citizen and spectator, part of the applicant's contingent, or an interested party. In this context, an interested party does not necessarily mean someone who is absolutely for or against the requested special uses, but someone who wants to be heard. If you do want to be heard, you will fall into any one or more of 3 categories. Number 1, you want to give testimony. This means you desire, under oath, to testify to facts relevant to the board's eventual decision. This is not the time to describe your feelings or announce your opinion, but to aver facts, and you are subject to cross-examination. Everyone so wishing to testify will be given one opportunity to do so. Second category, you want to be able to cross-examine witnesses, but please, that is just to ask questions of a particular witness, not to argue with him or her. Everyone wishing to cross-examine will be given one opportunity to cross-examine each and every witness. Or third category, you want to make a closing statement. This is the opportunity to tell the board how you feel or give them your opinion based on the facts adduced during the whole hearing process as to what their decision should be. Everyone so wishing to give a closing statement will be given one opportunity to do so. Again, everyone will absolutely have a chance to be heard. However, in order to try and add some semblance of organization, there are 3 half-sheets which were available to sign up to participate. One indicating your wish to testify, another your wish to cross-examine witnesses, and the last indicating your desire to give a closing statement. These were available at the door and continue to be available from Alice Hinkle. While signing up is not a prerequisite to testifying, cross-examining, or making a closing statement, I will initially be calling on folks using those sign-up sheets. Only after exhausting that list will I invite others to testify, to cross-examine, or give a closing statement. If you signed up on one of those sheets, I will keep those half-sheets current throughout the proceedings. Written communications sent in advance of this hearing or any written material intended as something for the board to consider is subject to Board Rule Article 5, Section 12, that 8 copies be provided. Any communications received that did not comply with this requirement may not be considered by the board. Those communications received which conform are marked as through Exhibit 20, and each board member has a copy, and another copy is made a part of the record in this matter. I will now review the chronological progress of the hearing. The applicant or his agent may make opening remarks, which has been done. The applicant presents evidence, one witness or document at a time, which we're in the midst of doing. I will place each witness under oath or affirmation. After each witness, the commission first and then interested parties have the opportunity to cross-examine that witness. And please, I remind you, this is the time only for questions directed to the witness testifying. Then, interested parties may present evidence, one witness or document at a time. I will place each witness under oath. After each interested party witness, the commission and or applicant have the opportunity to cross-examine each one of those witnesses. Then, rebuttal witnesses or documents may be presented by the applicant one at a time. Commission and or interested parties will have the opportunity to cross-examine applicants' rebuttal witnesses. Finally, surrebuttal witnesses or documents may be presented by interested parties one at a time, and the commission and or the applicant have the opportunity to cross-examine those surrebuttal witnesses. The last stage is the applicant is given an opportunity for closing remarks, and any interested parties are given the opportunity for closing remarks. Some sub-rules. As you may have heard, each session has a time limit under the zoning board's rules of 2.5 hours. However, we certainly don't want to cut off anybody right in the middle of something, so I will certainly let someone finish a particular stage when the time limit has been reached. Or, if there's very little time remaining at the end of a stage, I may simply suggest to the chair to continue the session rather than starting on another stage. I also have the discretion to call for short recesses. Under the board's rules, I have the duty to rule on the admissibility of evidence. While the strict judicial rules of evidence do not apply, I will exercise some equitable control of what is being presented, with or without an objection. We do have a court reporter here this evening taking down what is said during the proceedings. I ask all to be mindful of her job. She cannot take down 2 people talking at once. She cannot take down nodding heads or gestures. And while I'm sure she's very skilled, there's a limit to how fast a person can talk and expect her to keep up. I do ask for civility and decorum. This is certainly a public forum, but please be respectful of all who consider it important enough to be here. I ask to refrain from displays of approval or disapproval, and as now with all public gatherings, I ask you to turn off your cell phones or at least to put them on silent. It's been almost 4 weeks. We left off, Mr. Porter, I think, and Mr. Martin, you were on the witness stand. Mr. Porter, you were in the midst of cross-examination.
Thank you, Your Honor.
Martin, do you solemnly swear the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
I do.
Thank you. Collins, folks. You may.
Good evening. Mr. Martin, you may recall the last time we were here, we were looking over Exhibit 20, which is the decommissioning report that was originally prepared apparently for Whiteside County. Is that correct?
That's correct.
Now, at the last hearing, quite some time ago, you indicated that your intention was first, at that time, last time you indicated that the decommissioning plan, Whiteside County, had actually been tendered to the staff here at Lee County. Has any additional document been tendered concerning decommissioning to Lee County since our last meeting?
It is not.
Now, the decommissioning plan itself covers the entire three-county area. Is that correct?
That was the intent, yes.
And, okay, did that intent not occur?
It's really going to be up to the county boards to accept those plans, so if one county board needs something different than another one, then I suppose we will have to alter that plan. So the intent was to cover all three counties. It will be predicated by the acceptance of each county board.
Last time you mentioned that your intention was to provide an exhibit addressing the specific county requirements for each specific county. The one that's been tendered that I had marked as Exhibit 20 has a exhibit or attachment, Appendix A, that addresses Whiteside County. Have you tendered to Mr. Hinkle or anyone else here at Lee County an Appendix A explicitly addressing Lee County?
No, it is not.
Now, at the last hearing, we touched briefly upon the fact that Exhibit 20 does have a page 10 of 15, that describes the total decommissioning costs broken out among three different counties, Bureau, Lee, and Whiteside. And it references that Lee was going to has a quantity of 59 WTGs. WTGs are wind turbine generators, is that right?
That's correct.
Now, earlier last week, I received from Mr. Hinkle copies of some shadow flicker and noise studies that apparently have been filed recently with Lee County. First of all, is that information correct? You've recently filed some decommissioning and shadow flicker models with Lee County.
I believe that was at least 2 meetings ago that we did that. Yes.
And those shadow flicker models and noise models reference 53 wind turbine generators, not 59. Is that right?
That's correct.
Have you prepared a new decommissioning estimate based on the change that you've apparently made concerning your application?
At this point, we have not.
Which wind turbines have you now deleted, moved, or altered from the original application?
There was some near the Foley Sand Prairie area in the northern central portion of the project, and then some near the Green River State Wildlife area in the northeastern portion of the project.
Now, I understand that there were 3 wind turbines that were within a mile of the Foley Nature Preserve, which were turbines 28, 31, and 33. Have those 3 been removed from your application?
Yes, they have.
Now, I intended to get on decommissioning, but I'm going to have to move around a little bit here just to try to figure out what turbines you're now proposing. There were, strike that, the Illinois Department of Natural Resources recommended that the county require that no turbines be within a half mile of an Illinois natural areas inventory sites. And it identified that there were 4 such turbines near the near the Green River Prairie and Wetlands Natural Areas Inventory. Sorry, I have to strike that kind of question. The Illinois Department of Natural Resources made a recommendation that there be no wind turbines within a half mile of Illinois Natural Areas Inventory sites. And they identified that there were 5 turbines within a half mile of Green River Wetlands, Illinois Natural Areas Inventory site. Have those 5 been removed?
No, the consultation with the IDNR is ongoing, and the map that they were working off of was somewhat outdated with respect to the current layout. So their quantities were not correct with respect to what we've applied for in Lee County.
Well, I have a sneaky suspicion that the maps that I have, which were provided to me by Lee County, are also now outdated. Have you supplied an updated map to Lee County?
No, what's in our application is up to date.
And I have your application in front of me. Show me the map that you believe to be up to date.
In the body of the very first section, version 14 would be the second of the fold-out maps. And we have the most recent map.
Okay, it's entitled version 14 and dated July 4, 2012.
Yes.
All right. So I'll try it this way. What turbines were removed from the proposal that existed when you did your decommissioning report and submitted your materials to the Illinois Department of Natural Resources?
Yeah, and you went through a couple of them. I believe numerically it's, I have to go through it, but 33. Some of them were not only removed from the layout, but some of them were shifted in order to accommodate, particularly the Foley Sand Prairie recommendation from the IDNR. So 33 is missing or removed. I don't have a list with me. It was like 76. Took them out of the numerical order. Didn't just then renumber things. We kind of specifically just removed those turbines from the layout.
If one counts the turbines that are reflected on version 14, what number am I going to get?
I believe you're going to get 53.
So we understand then, when Lee County made its request to the Illinois Department of Natural Resources, it provided a map that is not being considered tonight. Is that right?
Specifically the map, that's correct.
So the Illinois Department of Natural Resources has never seen the current layout. Is that correct?
Actually, they have since seen the current layout. Like I said earlier, the consultation with the IDNR is ongoing.
And have they provided any report information to Lee County or otherwise concerning your new proposed layout?
They have not, as yet.
So Lee County has not, at this time, received the required IDNR report for the proposed project, right?
Actually, I believe that the report that was supplied would suffice. It's generally the same areas, and after long discussions with the IDNR, we believe the recommendations would largely be the same for that layout or this new, most recent layout.
Okay, but you've indicated that 5 turbines apparently were removed. You don't know exactly which ones, though. Is that right?
Again, I don't have a short list with me, but if I went numerically through these, I could probably establish it.
Well, I'm not sure of that because take a look. Okay, let's try that. When you removed turbines, did you remove the turbine numbers also, or did you renumber?
We just removed the turbine numbers. We did not renumber.
All right. From the version that was submitted to the Illinois Department of Natural Resources, were there any changes in locations of turbines?
If there were, they were in accordance with one or so of the recommendations by the IDNR.
Back to decommissioning. Now that you're using 53 turbines rather than 59, the cost per turbine has gone up, correct?
Not specifically, no. There will be some items that will be fixed costs, and there will be some items that will be adjustable per turbine. So we have to rerun the estimate.
In other words, you don't know what the cost per turbine is now, right?
At this moment, no, we do not.
Earlier, or strike that, the last hearing, you indicated that your intent was to provide a decommissioning report that this Zoning Board of Appeals could review before making its recommendation. Do you still intend to do that?
We do.
And do you have any idea when that's going to occur?
As yet, no.
Is the intent to have that occur after you have rested your case?
There is no intent to have that happen. If that's the case, if the proceedings go that fast, it's possible.
Is your intent to call any witness who actually prepared the report to testify concerning it?
That was not our intent, no.
Is your intent to call any witness who prepared the shadow flicker model to testify concerning it?
Yes.
Is your intent to call any witness concerning the noise study to testify concerning it?
Yes.
Mr. Shank has informed me that he informed your office that he would be willing to testify if Lee County requested him to do so concerning the Illinois Department of Natural Resources report. Have you made a request to Lee County to seek his input?
We have not.
Now, the current decommissioning report, which is apparently in possession of Lee County staff, though it was not provided to the ZBA except for me, provides that the total decommissioning cost for 59 turbines in Lee County would be $6,165, strike that, $6,165,500 plus $550,621 for contractor insurance and overhead fees. Is that right?
That sounds right.
So approximately almost $6.7 million in cost to decommission the Lee County proposed turbines. Is that right?
That sounds correct.
And as of last time we were here, your proposal was that a total of $13,721 be deposited for that, correct?
I don't have it in front of me, but that sounds correct.
And as a matter of fact, that total of $13,000 was to be for the benefit of the landowners and not the county, right?
That's correct.
Your petition states that all physical material comprising the project, I'm sorry, strike that. Your petition and the proposed ordinance that you've indicated you'll be in compliance with state that all physical material comprising the project improvements shall be removed to a depth of 48 inches beneath the soil surface. Is that right?
That's a point in a specific paragraph, but that sounds correct.
If you want to take a look at it, in your
Yeah, I've got
petition,
page 16.
page 16,
Yes.
the top paragraph is where you've promised to remove all physical material comprising the project improvements to a depth of 48 inches, right?
That's correct.
However, the decommissioning plan explicitly excludes removing any of the access roads, right?
That's correct.
So none of the costs associated with removing the access roads are contained in this plan, right?
If the landowner wishes the access road to be removed, we believe that it would be, or we know that it will be removed, as that's our agreement with our landowner.
Okay, but again, the point here was to establish a total cost associated with decommissioning so that Lee County could be assured that appropriate financial assurances were posted, deposited somewhere so they didn't have an abandoned project that wasn't decommissioned, right?
That is the intent, yes.
And your purported experts, let's strike that, who prepared the decommissioning report?
The current one you have is prepared by Sergeant Lundy.
Sergeant Lundy did not consider or determine the cost that would be associated with removing the access roads and disposing of the materials used to create the access roads, correct?
Actually, they were discussed in the development of the plan, but they were not included.
So, if indeed you were to honor your promise to remove all material within 48 inches of the surface, that would necessarily have to be included in the plan, correct?
That seems to make sense, yes.
So, as the plan sits now, it does not comply with your petition nor the proposed ordinance, right?
Actually, if you read our petition, under F, permits, explicitly states that prior to issuance of building permits, we commit to submitting a project decommissioning plan. So I believe this discussion is largely premature, as that was our intent, was to provide a decommissioning plan closer to the actual date of construction, as that is when the known cost would be better established.
But that's not what you did. You supplied a decommissioning plan to Lee County that I've marked as Exhibit 20.
For the intent of building that final decommissioning plan, yes, that was what we did.
Well, this plan isn't marked draft anywhere, is it?
Sure, I believe it was, but that was the white side one we're looking at, not the Lee County one.
Okay. It's actually marked final draft, right?
I don't have it in front of me, but could be correct.
And And again, that's the copy that you gave to Lee County, was the one marked final draft, right?
Explicitly for the intent of having discussions around establishing a final plan, yes.
Now, the petition also requires that a list of permits be provided which are necessary to complete the work identified in the plan, right?
I'm looking for that specific line, but
It'd be on page 17.
yep,
And you have not provided any list of permits necessary to accomplish the work, correct?
in that draft, I don't believe we have.
By the way, the engineer that prepared the decommissioning plan was supposed to be approved by the Lee County engineer or zoning administrator. First, is Sargent and Lundy an engineering firm?
Objection. We've already established about 5 times that the Exhibit 20 was not petitioner's decommissioning plan submitted to the county in support of its, as set forth in the petition. So, I mean, the objector has submitted it, and now is cross-examining Mr. Martin on things that never happened or never intended. We're going to be here forever.
Any response?
Again, the response is this is the only decommissioning plan that has been filed with Lee County. Whether they want to say they've done it or not, they've admitted that they did when they gave it to Mr. Hinkle, marked it as a final draft, and gave it to him with cost estimates for Lee County. They now want to back away from it because they know it doesn't comply. I want to point out to the county how it doesn't comply so that if ever in the future a real plan is ever done, maybe it will.
I think the objection to that particular question is sustained. Whether Sergeant, I mean, the Exhibit 20 is very clearly marked Whiteside County. He's testified that it was a, for lack of a better word, a boilerplate to engage in discussion about decommissioning. And I don't mind if he asked him, is Sergeant Lundy going to do the Lee County decommissioning plan and go from there, but not as to this one. Sustained.
Has Sargent and Lundy been approved by anyone at Lee County?
Objection. There's no
Overruled.
Explicitly approved, I'm not aware.
Let's start with that. Is Sargent and Lundy an engineering firm?
Yes,
Have you submitted a request to the zoning administrator or the county engineer to approve Sargent and Lundy preparing a decommissioning report?
specifically no.
To your knowledge, we'll strike that. The actual costs that were used by Sargent and Lundy were provided by an RMT Energy. Is that right?
In that draft for discussion purposes, yes.
And is RMT Energy a licensed engineering firm?
They may have engineers on staff, but no, they are a contractor.
And was anyone at RMT Energy, has RMT Energy or anyone from that firm been submitted to Lee County for approval?
No,
To your knowledge, does RMT Energy have any experience in actually decommissioning a wind turbine project?
specifically to decommissioning one, I'm not sure. I do know that they've constructed a good number of projects.
And to your knowledge, has Sargent and Lundy ever actually decommissioned a wind turbine project?
I don't know.
And Mainstream has never decommissioned a wind turbine project, is that correct?
That's correct.
And as a matter of fact, Mainstream has never built a land-based wind turbine project in the United States, is that right?
As Mainstream, that's correct.
And Green River Wind Farm Phase 1 LLC has never built anything, is that correct?
That's correct.
You would agree, well, strike that, is it your intention to have whatever consultant you eventually hire to provide a decommissioning report to again do so assuming that the entire project will be decommissioned at the same time, the entire project being the three-county area?
That's correct.
So you would agree, using Exhibit 20 as an example, that if any portion of the project has to be decommissioned, that the per unit cost for doing so is going to go up, right?
That seems logical, yes.
Since our last meeting, have you done any further determination as to how many cranes were contemplated by RMT Energy's estimate, whether it was one or more?
I have not.
Their estimate at the last page provides that mobilization, demobilization, and rental of general contractor equipment would have a unit cost for one quantity of $2,784,000. Is that right?
That's correct. The mobilization fees are typically a lump sum line item on an estimate.
So do you know if that mobilization involves one or more than one crane?
Specifically, I do not.
So it is possible that if even just one or a few turbines have to be removed, that first line item of $2.7 million will have to be met. Is that right?
I doubt that it would be the full amount, but it is possible, following the logic, that that's all one lump sum mobilization fee.
So you would agree then that assuming that the entire project is going to be decommissioned at the exact same time is not a conservative assumption, right?
I believe it's an appropriate assumption given the fact that these projects are meant to generate power to a certain point and then possibly repowered. They would be done in bulk.
Well, isn't it true that when turbines fail, they don't all fail at the exact same time?
It would depend on the cause of failure.
Once again, for the decommissioning plan, the assumption has been that a specific turbine will be used. What turbine is that?
I believe this follows actually I don't have it in front of me, I believe it follows the Siemens 113, the taller of the two turbines in the application.
And you understand, do you not, that if a different turbine is used, it will necessarily have a different amount of copper, metals, etc.
Yes.
And so, once again, the decommissioning plan is only an example rather than specific for this application. Is that right?
That's a very good way to put it. That's perfectly why we said prior to the issuance of the building permits, a final plan should be established. Then you'll know specifically quantities and sizes of the different turbine models.
But by that time, the Zoning Board of Appeals won't have the opportunity to determine whether or not the financial assurances that you are proposing be posted are sufficient, right?
No, but the issuance of those building permits could certainly be held up if it was not appropriate enough.
But you're stating that the determination of whether the financial assurances being posted are appropriate will fall solely upon whatever individual is issuing the building permit. Is that right?
No, I believe the county board should approve the decommissioning plan in its entirety prior to the issuance of those building permits.
Okay, so you just want to skip the public hearing process. Is that right?
No, I just think that that's the most appropriate time to do this, would be just prior to construction.
So are you suggesting that a public hearing be held in front of the county board to discuss the propriety of the decommissioning plan?
No, I believe the county board is perfectly well suited to make those decisions on their own.
Because county boards have members on them that are familiar with decommissioning plans for wind turbines?
The county boards are representatives of their constituents, and I believe they're informed individuals, and there will be a wealth of information coming out of these proceedings to make those decisions.
Are you proposing to bring a witness or an author of the decommissioning report in front of the county board?
That was not my intent.
And so your intent is then, we'll strike that. Do you intend to allow or suggest that an objector have the opportunity to present a witness to the county board to address the decommissioning plan we've yet to see?
I would leave that up to the county board to decide. That's not for my decision.
So we're all clear. I have retained an expert on decommissioning, but there's no report that I can hand him that you're willing to say that's our decommissioning report as it relates to Lee County, right?
At this current time, no. We'll be working off a draft provided prior to Whiteside County.
So why is it that you were able to prepare a final draft for Whiteside County's public hearing where you only have a handful of turbines, but you were not able to provide a decommissioning plan for the bulk of the project, which is here in Lee County?
The Whiteside plan as it currently stands is also in draft form, albeit it does represent final draft. Those discussions are still ongoing. And as the county board recently approved, decommissioning plan shall be established for their approval prior to issuance of building permits in Whiteside County. So in other words, the one that was presented to Whiteside County is a work in progress as well.
So, well, what about Bureau County? You did file this exact same plan in Bureau County, right?
Yep, for the intent of discussions as well. There has been subsequent plans and drafts filed with Bureau County and discussions with the Transportation Committee as well.
So, right now, let's strike that. So if I understand correctly, in Whiteside, you actually got some approvals. In Bureau, you're hoping that the hearings end soon. And here, you're not committing to provide a decommissioning plan before these hearings end. So if I understand correctly then, your intent is not to have an open public dissertation or cross-examination of the decommissioning plan, correct?
Again, my intent is, to the extent it has been further drafted, I will be more than happy to provide for public consumption, for the ZBA's consumption, a decommissioning plan specifically addressing commitments in Lee County. I believe that it should be, as represented in our petition, for the approval, the final approval is required of the issuance of building permits.
Well, have you hired Sergeant Lundy or RMT or anyone else to prepare a final decommissioning plan?
We do have ongoing discussions with Sergeant Lundy and RMT regarding further decommissioning plan drafting, yes.
We do have ongoing discussions. Does that mean you've hired them to do a final plan?
Technically, I believe there are change orders in place regarding the work they've already done, so I don't want to represent that we have hired them, but they would likely be the ones pending the approval from the county.
Okay. And obviously, you got to my next question. So you've entered change orders for Sergeant Lundy as it relates to Lee County. Well, you did so before you got approval from Lee County, right?
No, we haven't entered those change orders. We have not established that that work will specifically be done, as we still are seeking or will seek approval from Lee County.
You're just assuming that Lee County will rubber stamp the approval of Sergeant Lundy and RMT Energy, right?
I wouldn't make that assumption, no.
By the way, this last page of Exhibit 20 that has the meat, the content of the decommissioning estimate, the second note of it from RMT Energy explicitly says, industry standard wind farm construction assumed, project design not provided. Isn't that right?
Final project design, that's correct.
Well, that's not what it says. What it says is, quote, industry standard wind farm construction assumed, comma, project design not provided.
I don't have it in front of me, but I believe that's true.
Well, I don't mean to give you disadvantage. Let you take a look at it.
That's correct, that's what it said.
So to your knowledge, was RMT ever even given a copy of the actual layout, design of the proposed wind farm when it made this cost estimate?
Yes, I believe it would.
So you think that's an error in their note that they were not provided it?
Again, I think they need to make some assumptions regarding specifics on the design, and so I believe that note to be discussing details that they would need to assume regarding construction of a wind farm in the Midwest, for instance, and the types of soils and the types of cover, the types of access roads they would have. So I believe that's the intent of that note, but they were not provided a final design, as one has not yet been established beyond the specific locations that we provided in our application.
So when did you provide, oh, strike that. By the way, the RMT Energy document is dated April 30, 2012, which is before the Illinois Department of Natural Resources report dated June 20, 2012. And we know that the IDNR didn't have the current layout. So apparently, neither did RMT Energy, right?
Current layout, that's correct. That's why the number of turbines alone would have changed.
And do you have specific information that RMT Energy, I'm not talking about Sergeant Lundy, I'm talking about RMT Energy, was actually provided a project design despite the fact that they say they were not?
I can't recall it. I'm sure I was copied on an email that was sent to them with that, but I can't recall dates, exactly when it was.
So you're just assuming they were given a project design despite the report saying it was not?
That would be my assumption.
Could have been they were sent a design after they drafted the report?
No. I believe there might have been supplemental design and discussion, but, and in fact, I know there have been since, but I believe they would have seen a layout, whether or not they, how in depth they used it for the establishment of their estimate, I can't speak.
The plan uses a scrap metal value for copper of $2.90 per pound. Is that right?
That sounds correct.
It also assumes a scrap metal value for steel of $350 per ton. Is that right?
I thought the tonnage was higher on steel, but it was 380, if you're wrong.
Do you need to take a look at the document?
Let me just grab my Texas version. You're correct. I was wrong. I was going up to 280. 380 from the previous multiplier there. So you're correct. 350 a ton.
And exactly where did they get their values of $350 per ton for steel and $290 per pound for copper?
Back when this was established in April, I believe they used different indices. Most notably, they went to one of the websites that would provide specific information. I think it might be related to the NYMEX, but I could be wrong as far as the specific location.
Metal salvage values were determined using www.metalprices.com, right?
That's correct.
They did not conduct specific interviews of local salvage companies to determine what values are actually paid around here, did they?
Not that I'm aware of, no.
But isn't it true that their transportation costs don't include transportation to, say, California or New York, do they?
Objection, didn't we do this last time? Pretty special report, for sure.
No, I'll let you spoil it for
If that's true, I apologize. You have a better memory than I do.
Doesn't seem appropriate to ship steel or any commodities to New York or California from this location. So, no, I don't believe those were included.
Okay. So they used some type of estimate off of a national website rather than just calling local salvage companies. Right.
Exactly how the final tonnage, their value per ton was established. I can't speak to the spot price at that time when this was established, but I believe there's transportation costs built into that, so I believe they would have had to effectively decrease the cost to offset the salvage they would get.
And by the way, this is not an estimate. I'm sorry, strike that. This is not a quote being provided by RMT Energy. They're not obligated to decommission for these values, are they?
There's not a project yet built, so no, they would not be obligated.
They also went ahead and used the values as of a specific date, April 30, 2012. They did not use a 10-year or 20-year average for salvage values of metals, did they?
Again, it says based on current market prices, whether or not that includes a 10-year average, I'm not sure. That was accessed on April 30th, 2012. Doesn't mean that that was the date of the spot price for that day's value, so I can't speak to that.
Well, the exact quote is, metal salvage values are based on current market prices, estimated from www.metalprices.com, accessed on April 30, 12, and can vary considerably over the project lifetime, right?
That's correct. That's why we assume there's going to be an ongoing adjustment of any kind of security with project security in place.
So when it came to establishing the actual salvage value, wouldn't it have been more conservative to use an average rather than current values and a footnote stating, well, by the way, they're very fluctuant, they're very volatile?
Again, I can't speak to exactly what their current market prices mean. And yes, it's very appropriate to footnote that it will change over the project lifetime.
Are you aware that experts have found that the cost of decommissioning, after including the labor costs, can be as much as 90% of the original cost of constructing the turbines?
Again, you'd have to specifically point me to a project. I'd have to know a lot about the construction of it. I'd have to know a lot about the values for salvaging, where those transportation costs were associated. There's a lot that goes into it. So it seems like that could possibly happen, but I don't think that that's I don't think that that's an industry standard appropriate multiplier.
How much will this project cost to construct?
A couple of $1 million per turbine. So depending on the number of turbines finally established, plus substation costs, hundreds of millions of dollars.
And yet you're still proposing that only $13,000 be posted for financial assurances to decommission it, right?
Again, at this point, that is only for discussion. So I would imagine that the prices for salvage value commodities have changed since April when this was established.
All right. Let me show you, if I may approach, Your Honor, what I'm going to have marked as Exhibit 21, which is the document entitled Sound Impact Assessment, dated July 30, 2012, for the Siemens SWT 2.3-101 wind turbines. I'm going to have markers 22, the sound impact assessment for the Siemens 113. Okay. These reports for a sound impact assessment were prepared by whom?
GL Garadasan. And I'll preface this conversation by saying we're going to make GL Garadasan available to discuss these reports, testify on the details of them. So if you have technical questions for them, probably most appropriate to ask them.
Do you know when you're going to call them?
It really depends on subsequent meetings, depends on how long my testimony is going to go. We're happy to consider breaking my testimony to present them, but depends on subsequent meetings, the number of them, additional factors, everybody's schedules. So.
All right. I'm going to try to cover as much of this that you feel comfortable answering. If you don't, just let me know. Okay?
Sure.
Mainstream has not personally performed any noise studies in relation to this proposal. Is that correct?
That's correct.
And the petition and the ordinance indicate that, I'll strike that. Was there any approval acquired of GL Garad Hassan from Lee County before commissioning them to prepare a report?
Don't believe there was specific approval provided, no.
The ordinance explicitly required that. Isn't that true?
Don't remember, but
Well, if you take a look at page 15 of your petition, it provides that the petitioner, maybe you, shall have a third-party qualified professional approved by Lee County engineer or Lee County zoning administrator conduct an appropriate analysis of the noise impact to nearby properties. So, again, are you just assuming that Lee County is going to rubber stamp Garad Hassan as an approved third-party professional?
in submitting these reports, my assumption is that if there is an issue with Garad Hassan as the qualified party, that Lee County would make us aware of that.
Why didn't you follow the procedure you said you would in the petition, which would be get their approval first?
Don't have an answer for that. Don't know.
You're aware that Garad Hassan is a wind industry consultant, are you not?
I'm aware that Garad Hassan performs a variety of services, and most notably is a third-party engineering consultant for financiers to make sure the projects go through the appropriate number of due diligence. So I believe that they're qualified to perform this study.
Well, are you aware that most of Garad Hassan's clients are alternative energy companies?
By number or payment? Because I believe they probably do a lot of third-party work, and I can't speak to specifically how their finances would break down. I think that's more appropriate for Garad Hassan.
Well, you've seen Ms. Johnston and Mr. DeCousian's resumes, correct?
I have.
You have not supplied those with, well, strike that. I'm sorry to jump around here. The author of these reports for Garad Hassan is one E. Johnston, is that right?
That's correct.
And who is E. Johnston? What's her full name?
Aaron Johnston.
And Aaron works for and is supervised by Shant DeCousian, is that correct?
That's correct. I believe some of these questions would be more appropriately addressed by their direct testimony.
And again, if you don't know the answer, just tell me.
My understanding, yes.
And as a matter of fact, Mr. DeCousian and Ms. Johnston have testified in Bureau County, is that right?
That's correct.
So you know that Ms. Johnston is actually a member of several wind energy activist groups, isn't that right?
I don't think I would classify them as activists, but I know that she is involved in industry trade associations, yes.
As a matter of fact, she's involved in groups such as the Oregon Small Wind Association, the Oregon Wind Working Group, the Renewables Northwest Project, and Women for Wind Energy. Is that right?
I can't speak to that specifically. I don't have her resume with me.
Are you aware that she's not neutral, strike that, you would agree she's not a neutral scientist when it comes to studying whether there are detrimental impacts caused by wind turbines?
Objection.
Sustained. It's not his call.
Isn't it true, well, strike that, and again, tell me only if you know, and I'm aware that you sat through some of their testimony. Isn't it true that...
I'm going to object to the premise. I mean, the fact that Mr. Martin heard somebody testify is much different than personal knowledge.
I don't agree. If you've heard somebody make an admission.
I want to hear the question. I understand the objection.
Isn't it true that Garad Hassan has never testified or produced a report for someone in opposition to a proposed wind turbine project?
I don't know.
Isn't it true that Ms. Johnston is not a licensed engineer?
I don't know.
Do you know if any, strike that, do you know if the author of the report, the checked by person, or the approved by person, if any of them are licensed acousticians?
I don't know.
Do you know if any of them are a member of an acoustics professional association?
I don't know.
Now, they provided 2 noise models, correct?
Correct.
Why?
Our application included specific information for the 101, the Siemens 101, the Siemens 113 models. So they did those appropriate studies.
And they also did 2 studies, 2 shadow flicker studies, is that right?
That's correct.
And I'll have those marked in a little while. But isn't it true that the same authors of the noise studies were the authors of the shadow flicker studies?
I don't have them in front of me, but that sounds correct.
And as a matter of fact, Garad Hassan and these individuals have prepared reports for you in regard, strike that. As a matter of fact, Garad Hassan and these individuals have prepared 4 reports for you in 3 different venues, Whiteside, Bureau, and Lee. Is that right?
If you need 4 reports in each of those, yes.
And they've also, Ms. Johnston and Mr. Takuzian have come and testified for you in Bureau, correct?
That's correct.
How much in toto have you paid Garad Hassan so far in relation to this project?
I don't know specifically, but I believe it to be in a couple of dozen $1,000.
Over 50,000?
I don't think so yet. Specific to these studies.
Including time spent on testimony, travel, and this project in general. How much have you spent?
I don't know the specific number.
In toto, what do you estimate is going to be the cost paid over to Garad Hassan by the conclusion of these 3 hearings and this project?
I think that will largely depend on the testimony there to provide here in Lee County. If they need to travel to and from, if those meetings run long. So I think 50 plus.
You would agree that the formulas, the math, the studies necessary to do a shadow flicker study are completely different than the acoustics and noise modeling that needs to be done to do a sound assessment, wouldn't you?
I would, and I believe that there are many individuals out there who can comprehend both.
these noise impact assessments are merely models, they're predictions of what might occur in the future, is that right?
I think that's an appropriate question for the Raviston. Can't answer that.
Now, these reports at page I, Roman numeral, little Roman numeral 1, indicate that the original issuance of the report was January 18, 2012. Is that right?
That sounds right.
And it says electronic version only. So was that January 18, 2012 report provided to Lee County?
It was not.
What changes did you make to their report from between January 18, 2012 and July 30 of 2012?
There's probably too many to enumerate. In fact, I don't know specifically, but largely it revolved around discussions going on with the ZBA at the time regarding 3.1 times the height of the turbine setback versus 3.5. That could affect things greatly, and as it has in the application. And so beyond that, there's obviously been also the IDNR recommendations. There may have been, depending on the results, the need to shift turbines that, as modeled, would not have been in compliance.
Do you know if that occurred?
I believe, particularly in the most recent iteration, it did, but specifically which turbines, I'm not sure.
So Ms. Johnston's resume and qualifications have never been tendered to the Lee County engineer nor the zoning administrator for approval, correct?
I don't believe they have, no.
Likewise, Mr. DeCousian's resume and qualifications have never been provided to Lee County, is that right?
I don't believe so, no.
So once again, are you assuming that Lee County is going to rubber stamp this report?
I would not make that assumption, no.
And once again, your petition indicated that you would be only retaining a noise sound expert professional upon the approval of Lee County, but you didn't do that, right?
Well, objection, the petition doesn't state that the
Isn't it true that you did not seek approval of the professional before hiring them to do these reports?
objection, like the foundation, that assumes there is a requirement, there's not.
Isn't it true that the ordinance, your petition explicitly provides that the petitioner shall have a third-party qualified professional approved by Lee County or Lee County zoning administrator after submission of a resume and relevant work experience, conduct an appropriate analysis of the noise impact to the nearby properties?
Objection. The council's reading from the part of the petition that addresses what the applicant will do, assuming the special uses are granted before a building permit.
That's not at all correct, counsel, and you're making stuff up. That's not what it says. I don't know what that objection is.
I guess you have to point to the page.
Page 15 of the petition, and the question, I don't want me to repeat it, Judge, is, isn't it true that the petition explicitly provides that, quote, the petitioner shall have a third-party qualified professional approved by the Lee County engineer or Lee County zoning administrator after submission of resume and relevant work experience, conduct an appropriate analysis of the noise impact to nearby properties?
And my point is, the council is assuming that means that the references to the reports he's discussing. My point is, I think when you read the petition in toto, it refers to the noise analysis that will be done in support of the requested building.
My question right now is, doesn't it say that?
Yes, it does say that. This is all premised under number 8 back on page 5 regarding effective conditions to be suggested in our application. So these reports have been tendered. Again, I assume that if there is an issue with Garadasan's experience, that we will have to act accordingly.
So once again, you did not supply the resume and relevant work experience to the county before hiring Garadasan, right?
I don't believe we did.
This noise model assumes that the total project will consist of 81 wind turbines. Is that right?
That's correct.
How many model turbines did you tell Whiteside County the project would consist of?
Model turbines, or are you talking number of them, or
Correct.
or which model?
How many number of turbines did you tell Whiteside County the whole project would consist of?
Probably at that time it included the total, short of removing anything for the ID&I recommendation. So specifically, I don't know. It looks like it was 86 or 7, based on the decommissioning plan we discussed earlier.
How many total turbines did you tell Bureau County the total project would consist of?
Similar consideration for timing prior to any Lee County adjustments. All the adjustments would have been made in Lee County, so the number is 81
Present.
present.
Isn't it true, and you may change that number as we go along, is that right?
That is not our intent, no.
But it's happened before, correct?
On this project,
Yes.
we are officially applied in all 3 counties, so I believe the number to be 81 at this point. And I believe it to continue to be 81. So yes, it has happened before, but that was due to the timing of the Bureau and Whiteside applications in advance of final layout for Lee County.
Now, again, you've only studied 2 of the turbine possibilities, but your application makes clear that you might use any of 17 turbines, and perhaps other ones beyond that, right?
I believe the number is 18 different turbines that we were requesting the county to provide a process to which we would be able to use a different one of those for the final project prior to building permits.
And will that process include a public hearing where the public gets to review the shadow flicker study, the noise study, which might show the impacts to the public's homes?
That would be up to the county to decide.
Now, you understand and agree that the noise models that have been done will be completely different if a different model is used, right?
I wouldn't say completely different. I believe the procedures are largely the same. The format of the report, I don't see why that would be any different. The content, the final results, those would be potentially different. Depends on the noise signatures of the model, but again, I think that's more appropriate for Garadasan to speak to.
Well, Mr. DeCousian has informed you that if you change the model, the results will be different, right?
We are aware that there's potential for them to be different, yes.
So to date, a noise model of the actual turbines has not and cannot be done, correct?
No, we have noise model for the two proposed turbines that accompany the very specific locations we provided in our application. So, no, it's not correct.
These reports mention a transformer on page 4. They talk about wind turbine acoustic emissions summary, which is apparently supplied by some manufacturer data, and transformer acoustic emissions summary. Is there a transformer that's going to be present for every turbine?
With this specific model, I don't know. I believe so.
So at the base of each of these towers, there's going to be a transformer. Is that right?
That would be pretty typical, but again, I can't speak to that. That would have to let Garada Hassan answer that question.
Well, you're the one that selected the turbines that you provided to Garada Hassan, right?
We did select the turbine model, yes.
And when you say the transformer at the base is typical, that's not typical for every model of a wind turbine, is it?
Not everyone, but it wouldn't be, it's found frequently in a variety of models throughout the Midwest. So when I say typical, that's what I meant.
Do you know if the transformer noise is included in the tables that are found in the back of Exhibits 21 and 22?
I don't know.
There are models that do not use a transformer at the base of the turbine, right?
Yes.
Isn't it true that Garad Hassan has told you that the Siemens models they've selected are not particularly noisy nor particularly quiet when compared to other turbines?
Actually, I wouldn't call that true. I think you can draw a direct comparison, and we have talked about it, between the Siemens 101 and the 113 with respect to noisier or quieter. So we've specifically addressed those two models and their comparison. So with respect to the other models on the list, it's not yet been established what their sound characteristics are in comparison to the two that we provided.
Isn't it true that Chantekousian has informed you that the two Siemens models you've picked are somewhat middle of the road when it comes to noise production?
He's never stated that to us, no.
He has not informed you that the Siemens models are known to be particularly noisy, and therefore this would be a conservative exemplar or example being used, right?
No, he is not. But again, the 101, tell from the reports, is a somewhat noisier machine than a 113. So both are in compliance based on our conversations with GLGH.
Right, but you, Mainstream, Green River Wind, Farm Phase 1 LLC, did not go through your list of potential turbines and find one that you knew to be particularly noisy and then have that modeled so that you could then honestly say that this is a conservative model because we used a noisy turbine in order to do the noise study, right?
Yeah, I don't think that's appropriate at this point to provide that just on the basis of finding the noisiest one.
So again, you could pick one that's noisier than the models that have been modeled here today, right?
Yes, and I believe I would be held to supplying a sound study similar to the ones we have here to prove compliance with that new model.
But again, your intention is to do that after the hearing is concluded and you're no longer subjected to cross-examination, right?
Again, that's up to the county to give me instructions on how that subsequent process would be established.
So again, all these noise studies, shadow flicker studies, everything that we're here talking about now in your opinion, is all subject to change after the public hearings are closed, right?
No, I believe it's likely going to be largely locked into these models. We're requesting to have a subsequent, somewhat shortened process regarding those items that would have changed just purely on the new turbine model.
Now, you did touch on the fact that with the model that GL Garad Hassan did, the smaller turbine actually produced more noise, right?
That's my understanding, yes.
So one cannot assume just because it's bigger it's going to be louder, right?
One does not assume that.
Each turbine has a different noise output, and a specific study has to be done for each turbine, right?
I'm not sure that two of them would never match. I don't believe it's like fingerprints, but they would likely, it would be appropriate to restudy the new model and provide that.
By the way, we touched on the transformer question. And isn't it true that Garad Hassan did not use a specific model of a transformer and instead just used a generic sound power level for 103 dBA? Based on
If
that.
you want to read off something in the report, that's fine. I can certainly qualify that, but I think that's an appropriate question for Garad Hassan, not myself.
Do you know if Garad Hassan actually used a specific transformer that Mainstream is proposing?
I don't know.
And you're not proposing any specific transformer in any of the materials to coincide with each turbine, are you?
To the extent it would be included in these sound reports, I believe it's captured, but I don't have specific information on which one, no.
So you did provide 18 different possible turbine models to use. Are you going to provide the county with a list of transformers you might use for each turbine?
That was not our intent, no.
Do you know if the sound input, or strike that, do you know if the noise output differs depending on what transformer is employed?
I don't know.
You provided the turbine layout to Garad Hassan, is that correct?
We did, yes.
And you provided the turbine layout to Garad Hassan for their original report and for the subsequent report, is that right?
That's correct.
So Garad Hassan did not make any suggestions or determinations as to where turbines should be located, is that right?
Actually, at each iteration, there would be a subsequent call regarding the results. Some of those, the need for changes was not a result of their report, so it would be just a subsequent layout provided to them to rerun the report. But yes, there was absolutely, depending on some locations in proximity to other turbines, some suggestions regarding the likelihood of moving something, and then a rerun of the analysis to make sure it was in compliance.
Okay, earlier you told me that you removed 5 turbines from the original application or proposal, in part because of removing some by the Foley Nature Preserve. And you did not explain why the others were removed. Am I characterizing that testimony correctly?
Why they were removed? No, but I did explain where they were removed.
Okay. So we know that you removed 3 turbines as a result of the IDNR report. And there were 2 other turbines that were removed because why?
Actually, it might have been the other way around. There was probably other turbines removed first as a result of the February recommendation by the Lee County ZBA to have 3.5 times the height of a turbine be the multiplier for the wind ordinance. And our application coincides with that, so that would likely remove a couple. And then again, there might have been the ability to shift on the buildable lands. And then we received the IDNR recommendations and remove ones that follow some of those.
Okay, so none of the turbines removed were removed as a result of any sound study that was done, right?
Removed? No. Actually, there may have been one near the Sand Prairie Habitat area, not the fully Sand Prairie, but the Sand Prairie Habitat that was removed. Specifically which number, I can't recall. And then there was other ones that were moved but not removed.
Okay.
In order to get in compliance for the modeling.
Your original noise studies did not consider the noise impact on the natural areas, did they?
They were considered, but they were not a driver in the layout.
Well, let me be more specific. At least in the studies that were done in Whiteside County and Bureau County, there was absolutely no discussion about performing any analysis at receptor points in Illinois natural areas, inventory sites, or nature preserve sites, correct?
That's correct. We had not seen the IDNR recommendations with respect to that, and particularly in Bureau County, there isn't anything in proximity there, so it wasn't appropriate.
And so as of your January 18, so as of the GL Grad Hassan January 18, 2012 original issuance of this report, which was sent to you by electronic version, at that time they had not studied any receptor sites at a natural area, correct?
That's correct.
And so the change from 58 or 59, depending on what you read, turbines in Lee County down to 51 was not the result of any noise study to any natural areas inventory site, right?
No. First of all, it's 53 in Lee County, not 51. And as you see on the front of each report, the end of their document number is an R, R11, R13, and they're typically revisions, is my understanding. I'll let you ask that question from GLGH. But most notably, and most recently, there were natural area considerations taken as a result of the IDNR recommendation around the INAI areas and the Foley Sand Prairie. So there's multiple revisions here, a variety of reasons why they changed as the application was being established. And again, some of them were based on the recommended multiplier by the ZBA. Some of them were based on proximity to natural areas. Some of them were based on possibly proximity to other turbines.
Did you direct GL Grad Hassan to do any background noise studies at any locations in Lee County?
No, we did not.
Do you know if the software used by Grad Hassan has been verified by any post-prediction studies?
I don't know. That's an appropriate question for them.
This report indicates there are, both these reports indicate there are 600 sound receptors in Lee County. but the tables reference 800. Do you know why the difference?
Probably the biggest difference, particularly in the Lee County reports, is the addition of effectively a grid on the INAI areas to establish points to model against. But, I guess appropriately I should say, I don't know. That sounds like the one assumption I would make.
Isn't it true that you directed GL Garad Hassan to perform their noise studies to the homes, the structures on residential properties?
We instructed the Garad Hassan to comply with the Illinois Pollution Control Board standards, and I believe they've done so.
Well, you did have a discussion with Garad Hassan explicitly about whether the noise study should be done to property lines versus buildings, correct?
Correct. We discussed that at length. We reviewed the Illinois Pollution Control Board standards. You'll see on each map red indicators, red being something that would be a Class A property. Many of those are homes. Some of them are plots of land. Some of them are natural areas. So, yes, we had that discussion.
And you were the one, we'll strike that. Was it you personally who made the decision that the tables would only consider the receptor sites as structures as opposed to property lines?
No, that was definitely a discussion and a conclusion that myself and Ms. Johnston came to regarding the Illinois Pollution Control Board standards.
And before I move on to Exhibit 23, of those 600 receptors that were considered in this report, 219 were in Lee County. Is that right? If you know.
I don't know. I could just do the math on it. I don't know specifically.
Are you, well, strike that. From the text of the report, are you aware that 196 out of the 219 receptors were non-participating landowners?
Again, I don't know the breakdown.
Did you see in the text that over 90% of the homes that are identified as receptors of the potential noise are non-participating landowners?
Specific to the 90%, I don't know.
If the text of the report would indicate such, you'd have no reason to dispute it, would you?
No.
Now, the receptors that you've identified are only homes, is that right?
No, there's also, again,
I'm sorry, I'm going to withdraw the question. You've already said. In addition to the homes, there's also been added some various receptor points at natural areas inventory sites. Is that right?
That's correct.
Other than homes and natural area inventory sites, are there any other receptors identified in this report?
In tabular form, no. There are the maps and the contour lines on the map were used to look for other areas that of appropriate concern for the Illinois Pollution Control Board standards. But those were the two that were presented in tabular form.
Okay, so the table does not consider whether there were any noise impacts to schools, churches, retail buildings, commercial buildings, if any are in footprint or near the footprint, right?
Actually, I believe the table would accommodate that. So I misspoke. If you're talking just residences, we consider that primary structures and have gone through a rigorous review of the area with respect to what would be considered a primary structure and established as a receptor accordingly.
Did you provide the list of receptors? Strike that. Did Mainstream provide the list of receptors to Garad Hassan, or did they determine it themselves?
We provided that to you.
Okay. And do you have a copy of that list?
With me this evening? No, I do not.
And is there any document that you could show me that would show that list includes churches, schools, hospitals, residents, other buildings beyond residences?
I would have to find it, but I don't think there are many of any of those in this area. So I'm not sure. I don't want to tell you that it's going to have schools on here, for instance, if there aren't any schools in the area.
Do you know if any of the receptors are any of those types of buildings?
I do not, off the top of my head, no.
Now, I've handed you a copy of what's been marked as Exhibit 23, which is the Illinois Pollution Control Board regulation concerning sound emitted to Class A land, and specifically 901.102. Do you have that in front of you?
I do.
And you had mentioned that you and Garad Hassan reviewed the Pollution Control Board regulations and came to a determination that you would only consider the structures in the table as opposed to the property lines, right?
No, actually, the property line discussion largely stemmed out of the review of the Class A areas, specifically. There's a designation, I believe this looks short with respect to the entire document, regarding natural areas being considered Class A land classes, and so those...
Okay, I know the section you're talking about. I'm going to mark it as an exhibit next. But if we can, right now, I want you to take a look at 901.102, which provides that, does it not, that no person shall cause an emission of sound which exceeds the allowable level, and I'll quote, measured at any point within the receiving land, right?
That's correct.
And so, and by the way, it's 901.102B that happens to relate to nighttime Class C land emanating sound to Class A land, right?
That's correct.
And I'll cover more of this in detail when the noise people are here, but in general, Class C land is where the turbines are located. Class A land is where the people are living, right?
Actually, no. All of the land uses and classes established are are discussed in section 901.101 and reference LBCS codes that specifically spell out a hotel versus car dealership and the appropriate classification of those lands. So largely throughout this area, the turbines are on extensive Class C land, and they are neighbored by extensive Class C land.
However, if someone lives on agricultural land, the home and its yard and the parts of it that are used for residential purposes are considered Class A land, correct?
The Class A land would be the home.
Now, you mentioned the LBCS codes. If you take a look at the last 2 pages of the document I gave you, you'll see that what Class A land is actually described as is residence or accommodation functions, correct?
That's correct, under the 1,000, and then it has further breakdown there under.
And I believe you told me in the past that you've reviewed some of the Illinois Pollution Control Board cases that relate to what the accommodation functions are for residents, right?
No, I think you're mischaracterizing the word accommodation functions. This is an overall heading for the Class A land. It's residences or accommodation functions, underneath which 1,100 would indicate a private household. 1,300 would indicate hotels, motels, or other accommodation services. So that's the breakdown thereof of the LBCS codes.
But you've actually read some of the Pollution Control Board cases that address what determines whether it's Class A or Class C land, right?
I've read one in particular, yes.
And the issue is what it's being used for, right?
That's why they're land-based classification codes.
And so if it's being used for a residential purpose, such as your yard, your gazebo, your deck, you would agree that the Illinois case law provides that's Class A land.
I believe it would depend on the situation. I don't think that that's a blanket statement that I would agree with.
Right? If you have it using your yard to grow corn, that's going to be Class C land, right?
Correct.
But if you're using your yard to recreate, like a normal small farmette, then that's going to be Class A land, right?
Again, I'd have to see the layout of that farmette and what exactly is being.
But you didn't do that level of analysis. Instead, you directed Garad Hassan to only do its analysis to the structure, right?
We believe that Garad Hassan performed their results in accordance with the Illinois Pollution Control Board standards, performed their modeling.
And so if someone owns, say, 5 or 6 acres, or even 20 acres, this noise study only determines what the prediction is for the noise at the building, not anywhere else on their 5, 10, or 20 acre parcel, right?
No, that's incorrect. There's a variety of smaller parcels indicated on the map, indicated by red, showing that they're Class A properties, and it specifically gives contours on each map with respect to the expected sound result at those locations.
Well, there's a table attached to each report as appendix, I believe it's B. Isn't that right?
There's a couple of tables.
Right. But there's an appendix B that identifies the receptor locations and the associated sound levels, correct?
Yes, again, those are, in addition to the maps, constantly the result of the study done by GLGH.
And those receptor locations are the structures, not the property lines, right?
Some of them actually could be considered the property line if the structure is the only Class A property.
All right, well, let me be a little more specific. If someone owns a piece of land, it has a property line that is identified by its legal description, right?
Typically, yes.
And you directed Garad Hassan not to use that property line as identified by their legal description, and instead determine the exact location of the home and use that in order to determine the receptor location, right?
No, we directed Garad Hassan to follow the Illinois Pollution Control Board standards guidelines, and their results indicate a variety of Class A land and a variety of Class C land throughout the area. Some of that is at the property line. The house would absolutely be Class A land. So I believe they did exactly what they were instructed to do, which is to follow those guidelines.
Well, actually, you know exactly what they did. What they did was, if your land was in a zoned agricultural area, they only used the structure, right?
Actually, I don't know that to be true.
Okay, so I'll have to ask Garad then, correct?
That seems appropriate.
Now, you do know, because let's take a look at the body of Exhibit 21. And in particular, let's take a look at page 5. And isn't it true that this report explicitly provides that the estimated accuracy of the model they used, which is something called ISO 9613, is plus or minus 3 decibels?
That's what this report says, yes.
And you've heard Mr. Dekuzian inform you and me that the manufacturer's data they use to determine the noise output for the Siemens turbines has a margin of error of plus 2 decibels, right?
Specifically where that 2 decibels came from, I'm not sure.
But if you take a look at the table, which is the heart of this document and identified as Appendix B, I'll strike that. Have you learned in your process of being involved with these projects, and in particular this project, that the 1,000 hertz level is the level that the human ear picks up the most amount of sound?
Specific to that octave hertz, I'm not sure.
If you would take a look at Appendix B, and you'll see that at the 1,000 hertz level, there's a limit identified as 41. Do you know where that limit came from?
That would be the Illinois Pollution Control Board standard, nighttime limits, I believe.
Okay. And isn't it true that if you look at, for example, receptor 40, that the model that was used by Garad Hassan made a prediction that at the 1,000 hertz level, the decibel reached, given the conditions that they used, would be 38.9 decibels. You see that?
Which receptor is it?
Receptor 40.
That's what the report says, yes.
And because the report has indicated that it has an accuracy of plus or minus 3 decibels, if one were to add the 3 decibels, there would be an exceedance of the PCB limit, right?
If one were to add 10 decibels, there would be an exceedance of the IPCB standards as well.
Yeah, but that's not the margin of error. I'm just asking about the margin of error. If one adds the margin of error that's identified in the very report that's been submitted to the output at the 1,000 hertz level for receptor 40, there's going to be an exceedance, correct?
Actually, 40 is a participating landowner, so I don't know that that's appropriate here, but I believe that's a question perfectly suited for garage sign.
So you don't know.
Well, I can add 3 to 38.9, yes, and put it over 41, but I don't think that, whether or not that's appropriate to do so would be for GLGH to speak to.
Of course, that wasn't straight. If you take a look, now you're concerned that that happened to be a participating landowner. We can move on down. Take a look at, for example, receptor 46. That one again is at 38.1. If you add the margin of error, you're in exceedance of the maximum decibel limits allowed by the Illinois Pollution Control Board, right?
Again, it seems like an appropriate question for GLGH.
And that continues, by the way, at receptors. Receptors, by the way, are homes. At homes, 125, 126, 127, 131, 140, 142, 143, and 148. Isn't that right?
I've not done the math on all of those, but if you say so, that would, adding 3 to each of those would take that over 41.
Thus, the very report that you've submitted, when someone takes the time to dive into it, explicitly shows possible exceedances at 10 different homes, right?
Again, whether or not they're possible exceedances, that's a question for GLGH to answer.
Well, okay. You will want to submit the report that indicates that its level of accuracy is plus or minus 3 decibels. And then you provided a chart that identifies the decibel outputs. So wouldn't you agree that the logical conclusion here is that if you add the margin of error, you've got at least 10 exceedances?
Asked and answered.
I agree. Let's move on.
By the way, if one were to add 5 decibels, which would be including the plus 2 margin of error for the manufacturer's data, are you aware that 31 homes would be an exceedance?
Again, I had numbers all day, and I think it's inappropriate at this point. I think that's for GLGH to answer.
We'll strike that. Given that the report itself indicates that there's a plus 3 margin of error for this report, are you going to make any changes to your layout in light of the fact that at the 1,000 hertz level, there are at least 10 homes that are at 38 or higher when the decibel limit is 41?
That was not our intent. Our intent was to provide these studies through Garage Hassan and find out what the results were. They are telling us that they have complied, or that the layout complies with the Illinois Pollution Control Board standards. So it's not our intent to alter their results. I think that's inappropriate.
Well, isn't it true that the result is actually that at the 219 receptors in Lee County, their model predicts that they're within the PCB limits with a plus or minus 3 decibel margin of error? That's what the results are, right?
The results speak to a deviation, a statistical deviation. Whether or not it's appropriate to apply that, I think, is a perfectly appropriate discussion with Garage Hassan.
Mr. Hearing Officer, I'm going to move on to another topic, the flicker studies. What time do we go till?
10:30.
Oh, before I do that, you're aware, are you not, that the Illinois Pollution Control Board regulations explicitly provide not two different methods for noise pollution, one being exceeding these maximums, and the other one just causing an unreasonable interference with the neighbor's use and enjoyment of the property. Are you aware of that?
I don't have that specific quote in front of me, but I have heard you quote that before, yes.
But my question is, do you agree with that characterization?
I agree that our project as modeled complies with the Illinois Pollution Control Board standards.
That's certainly not the question I asked. Let me give you the... Here we go. This should be 24 here. Do you have Exhibit 24 in front of you now?
I do.
And isn't it true that this is a copy of certain definition sections of the Illinois Pollution Control Board noise regulations?
I'm not sure if it's a complete copy, but it does appear to be so.
It is definitely not a complete copy. It's only the pertinent portions. And if you'll take a look, you should have the definition of noise pollution contained in that document. Do you see that?
I do.
And that definition is the emission of a sound that unreasonably interferes with the enjoyment of life or with any lawful business or activity. Is that right?
That's what this says, yes.
And so, do you understand that noise pollution can occur even if the maximum decibel limits are not exceeded?
Objection, also
We talked earlier about background levels. And isn't it true that Mainstream did not direct Garad Hassan to do any background studies in Lee County?
That is still true, yes.
And have you also learned that it is the increase above background that is usually considered by acousticians and noise experts as evidence of noise pollution?
I don't know that, in fact, no.
I will ask Garad Hassan about it. I'm going to have marked as Exhibit 25 the shadow flicker assessment for turbine. 26, the shadow flicker assessment for 113 turbine.
Curious, Judge. These have all been submitted. Outside of this, I don't know if you got double up on the submittal of these reports. Yes, sir.
And I'm sorry, Mr. Martin, but while the judge is doing that, I need to jump back quickly to Exhibits 21 and 22. If you would, take a look at page, well, it's actually an unnumbered page, the page right behind the cover page. Are you there? It's entitled Important Notice and Disclaimer.
That's correct.
And isn't it true, and let's look first at the 101. Actually, they're identical. Both Exhibit 22 and 21 are identical notices and disclaimers. Is that right?
Yes.
And isn't it true that in the first paragraph of that notice, important notice and disclaimer, Gurad Hassan explicitly states that it is not in any way to be held responsible for the application or use made of the findings and results of the analysis herein.
And the rest of that is, and such responsibility remains with the client.
That's correct. In total, that's correct.
And the document also provides that it should not be relied upon by third parties for any use whatsoever without the express written consent of GLGH. Is that right?
That's correct. That's the next sentence.
Do you have express written consent for Lee County to rely and use this report in any way?
I would have to double check if so, it's given by email.
So you don't know, is that right?
I don't know.
So without that express written consent, GLGH has no liability for anything contained in this report, and it's not to be used
Mr. Porter, let's
by a third
let's
party.
try and
Is
stop
that correct?
asking Mr. Martin legal conclusions.
I wasn't asking for a legal conclusion.
Yeah, you did. Ask him if they're liable. That's the legal conclusion.
All right, you're correct, Your Honor. You would agree then, would you not, that GLGH has explicitly informed Mainstream that its findings and analysis, that it's not responsible for any of the findings and analysis of this report, right?
That's correct.
But Lee County has an ordinance that explicitly requires that a noise analysis be done upon which they can rely, right?
Specifically, which ordinance would be in effect, I'm not sure.
All right, well, let's put it this way. Your special use permit explicitly stated that you would provide a noise level study to Bureau County upon which they can rely, right?
Absolutely, that transfer of reliance is why we submitted these reports to the county.
And if we now take a look at what we had marked as, I believe, 25 and 26, Your Honor, shadow flicker studies.
Yes.
Those studies also contain that same language that GLGH is not in any way to be held responsible for the application or use made of the findings and results and analysis herein, right?
This would be the same language, correct.
And again, as far as the shadow flicker studies, they've stated that the report should not be relied upon by third parties for any use whatsoever without the express written consent of GLGH, right?
That's what he said, correct.
And again, you haven't seen any such express written consent to allow Bureau County or anyone in this room to rely on this report, right?
I did not say that I hadn't seen it, I said that I'm not sure.
You don't recall seeing such a thing.
I don't recall.
Once again, 2 turbines were modeled as far as shadow flicker is concerned, is that right?
Same two as previously mentioned, yes.
And once again, it appears that there was actually 3 versions of this report. One, January 18, 2012, one, February 3rd, 2012, and then another one, I guess, July 5, 2012. Is that right?
You must be talking off of Exhibit 26 rather than 25, but there are 3 dates there, yes.
All right. Oh, so why is it that there are 3 dates for Exhibit 26, which relates to the 113, and only 2 dates for the 101?
Likely a revision related to the discussed setbacks in earlier February, or perhaps some of these iterations that have been done had not actually been technically issued from Narada-san to Mainstream, rather than just run for analysis and then rerun prior to being issued.
Well, the 3rd version is when the INAI sites were included, right?
That's specifically what it says here, yes.
Once again, did the county approve Garad Hassan as the entity that should be doing a shadow flicker study?
Suggestion, again, Lax Foundation suggests there is such a requirement.
You can make it to be consistent with the same one before we went back. I assume the language of the petition is the same.
Well, no, actually, the shadow flicker says prior to the issuance of the building permit, the petitioner must retain 13.
I'm sorry, Your Honor, what's the objection?
She has a question that presupposes something that, or is it sustained?
Was Garad Hassan strike that? Was the use of Garad Hassan discussed with Lee County before the report was generated?
Explicitly discussed, I'm not sure.
Mainstream did not draft any portion of this report, did it?
No, we did not.
And once again, the report was drafted by the same person who drafted the noise study, correct?
It was authored by 2 of the 3 same people, checked by would be a different party than the previous ones.
Now, the Lee County ordinance explicitly requires that a model study presenting conservative number of hours of shadow flicker, which may appear on a primary structure of a non-persistent property owner, be provided, right?
Objection, what are those ordinances?
I'm not aware of anything specifically to that effect in any of the existing ordinances in Lee County.
Well, again, I was using a shorthand language there, and I apologize. You've indicated earlier in this proceeding, and even before you filed this application, that Mainstream is going to comply with the proposed ordinance that did not get passed. Is that right?
Not specifically to every detail of that, no. I said we would largely follow that as a guideline.
And you filed a petition wherein you've indicated that the petitioner must present to the Lee County Zoning Board of Appeals a model study presenting a conservative number of hours shadow flicker may appear on a primary structure of a non-participating property owner, right?
Objection, he's left out the introductory clause again prior to the issuance of the building permit.
Counsel, you can conduct redirect. I assume the judge will allow you to do that.
Come on, counsel. You got to have the proper foundation for questions. You just can't pick out words. Ask the question with the whole clause.
Isn't it true that you have filed a petition indicating that prior to the issuance of a building permit, the petitioner must present to the Lee County Zoning Board of Appeals a model study presenting a conservative number of hours shadow flicker may appear on a primary structure of a non-participating property owner.
That's correct.
And do you consider this report to be conservative?
The 113 model is certainly conservative.
And so you don't believe that the 101 report is conservative?
I believe it's conservative to the extent that 101 is used. In terms of height, it would be not as conservative as the 113, but there are a variety of assumptions that go into the modeling that would be the same. So those conservative assumptions would be the same.
Well, one of those assumptions is what I want to talk to you about. Isn't it true that both of these studies at page 5, section 3.4, explicitly discount the results that they came to as to how much shadow flicker would exist by 61.1%?
That discount is largely, or is related to the number of daytime sunny days as appropriately established by GLGH. During those sunny days, it's effectively full-blown conservative assumption. So that's the one realistic assumption given some very specific data established by GLGH.
GLGH came to a conclusion. If you'll, let's take a look at Appendix B. Let's use the 113 report. It should be Exhibit 26, I believe. If you take a look at Appendix B, they came to a specific conclusion about the total hours per year that shadow flicker would occur without considering cloud cover, right?
There's a column for that, yes.
But the text of their report doesn't use that column. It uses the next column, where they have discounted their results by 61.1% based on an assumption that that's how often there's going to be cloud cover. It's 61% of the time, right?
Based on an assumption with some backed up data, yes.
They don't provide, by the way, that data anywhere in here, do they?
They reference where they established it.
Well, it says based on some Rockford data is all it says, correct?
Let's just ask the question.
Am I right? All it says is based on some Rockford data.
I don't think it says based on some Rockford data, no. I think that's if you want to read it.
Let's take a look back at page 5. According to data gathered from Rockford, Illinois Meteorological Station, it has been estimated the cloud cover is sufficient to nullify shadow flicker occurrence 61.1% of the time.
That's correct.
So they don't provide the actual data that they're using in order to do that 61.1% discount, do they?
Directly references a meteorological station in Rockford.
And are you aware that other venues, like Wells County, Indiana, have explicitly required the shadow flicker studies not discount for cloud cover?
Yes, Your Honor.
Did you direct Garad Hassan to discount for cloud cover?
No, we did not.
Wouldn't you agree that it would be much more conservative to not use those discount numbers?
I think that would be wholly inappropriate. It's not likely to have 365 days of sun. So I believe that to be perfectly appropriate what they used here.
Wouldn't you agree that it would be more conservative to not discount?
Conservative, Sure. Appropriate? No.
On page 4, Garad Hassan lists what it believes are conservative assumptions that it used when it did this report, right?
That's section 3.3, yes.
And at the fourth point of 3.3, Garad Hassan states that the occurrence of cloud cover has the potential to significantly reduce the number of hours of shadow flicker. Is that right?
That's part of that number, yes.
So wouldn't you agree that Garad Hassan is acknowledging that not discounting for cloud cover is the conservative method to do this report?
No, I think you have to take the total of number 4 together to consider that a conservative assumption. Discusses using the sun as a point flight source rather than a disk. Again, I think these are appropriate questions for GLA. When I read that, I would take the entire thing and consider that conservative.
Now, when you take a look at this report, you'll see that over 80 homes are subjected to some shadow flicker during the year. Is that right?
Specific to 80, I'm not sure.
I'll let the panel count it for us, but would that surprise you to learn that over 80 homes are subjected to some shadow flicker throughout the year?
That would not surprise me, no.
And as a matter of fact, there are homes that are subjected to shadow flicker as much as 222 days per year. Isn't that right?
A participating landowner, yes.
Okay. Well, if there's a non-participating that's subjected to 211 days per year of shadow flicker, another at 200 days per year of shadow flicker. Isn't that correct?
That's correct. It wouldn't be for the entire day, but that'd be as modeled, correct. And again, I assume we're talking off of the exhibit number 26 with the Siemens 113 model.
Correct. So, by using their 61% reduction figure, with the first home, they found that that home would be subjected to 152 hours of cloud cover. And they reduced that all the way down to 59, taking into account cloud cover. Is that right?
That participating landowner, yes.
And they did that for all the landowners, including the 90% of non-participating landowners, right?
I don't know that 90% is correct, but yes, they did discount everything for that Rockford meteorological data.
And so the next home down that's going to be subjected to 179 days of shadow flicker at over 92 hours, they reduced that down to 36. Is that right?
Those 36 would include those conservative assumptions in their report, but yes, they did.
Isn't it true that even on the 101 model, Exhibit 25, there are 60 homes subjected to more than 10 hours of shadow flicker when no discounting for cloud cover is concerned?
The objection it states the conclusion of the report. And counsel suggesting that there is actually a without cloud cover reality that is being discounted. That's the reverse.
Isn't it true that the document explicitly provides that 60 homes will have shadow flicker when cloud cover isn't considered? And that's for the 101.
Same objection.
Specifically to 60, I'm not sure, which approximate.
And as a matter of fact, those 60 homes, those are those that will have more than 10 hours, according to this report, when cloud cover is not considered, right?
According to those conservative assumptions for when the cloud cover is not considered, yes, that's correct.
And with the 101, even when you take into consideration cloud cover, $35 homes will be subjected to 10 hours or more of shadow flicker during the year, right?
That looks like an approximate number, yes. Many of which are participating landowners.
But most of which are non-participating, right?
I don't know about the number of guesses in town, so it looks like it's 60-40 non.
Well, actually, out of the 35 homes subjected to 10 hours or more, 24 of those are non-participating, right? Again, just looking at the smaller model.
Might actually be 25, but
Okay. And as to home 690, which is a non-participating home, that this report shows will have 166 days of shadow flicker, even taking into account cloud cover, it'll have 28 hours of shadow flicker, right? I'm sorry, 31 hours of shadow flicker, right?
as modeled, yes.
And your petition explicitly provides that shadow flicker shall not exceed 30 hours per year, right?
Yes, so I'm assuming that the county is going to provide a condition on our permits that would hold us to 30 hours per year as we represented here, but that's for the county to establish.
So the layout as you've proposed, even using your model and completely discounting for shadow flicker, even using the smaller turbine, is not in compliance with the 30-hour requirement, right?
Even using those conservative assumptions in the days without cloud cover, it can be in compliance with the 30 hours of shadow.
Okay, but the report predicts 31 hours, even with the 101, the smaller wingspan, right?
For 4 of the properties, including 3 participating landowners? Yes, that's correct.
And if you take a look at the 113, if you don't discount for cloud cover, there are, at least 30 homes that have more than 30 hours, right?
I don't think it's inappropriate. I think it's inappropriate to not discount for cloud cover. In this column, there would be more than 30, or approximately 30, sure.
And even if you do discount using the 61% figure without the supporting data, there are 6 homes subjected to 30 hours or more of shadow flicker, right? Using the 113 prediction.
That's correct.
And so, and by the way, 4 out of those 6 are all non-participating landowners.
That's correct.
And so once again, with the very studies you've provided by your experts, you're not in compliance with your petition.
The studies indicate where the appropriate steps to take are throughout our layout. So again, we can bring those into compliance to the 30 hours. So the study provides a certain number of results, and then again, I believe the county's we'll put an obligation on us, the developer, to be in compliance with a certain number.
Okay, now I'm running out of time, but if you look to Appendix C, there's been a new addition to your report, which are the INAI, the Illinois Natural Areas Inventory Sites. Is that right?
That's correct.
And if we jump over to the 113-meter turbine, there are 33 INAI site locations which will be subjected to shadow flicker. Is that right?
In total, yes, that appears correct.
And isn't it true that the Illinois Department of Natural Resources, through Keith Schenk, has indicated that there should not be any shadow flicker on any INAI sites?
No, I believe Keith Shank has indicated that we may have concerns regarding behavior of different species with respect to shadow flicker.
Mr. Porter, how much longer